Hear ye, hear ye, hear ye. All rise. Florida's District Court of Appeal, First District is now in session. All those with cause to plead, draw nigh, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Be seated. Good morning, ladies and gentlemen. Thank you for taking the time out of your schedule to come. We have 3 cases on the docket, and for the first time in my 7 years on the court that I've been on appeal for oral argument, we are not going to take the cases in the order that they appear, even though we always announce that we will, but this time we're going to take the second case first, the third case second, and the first case third. With that, Mr. McCabe, you ready to proceed?
Yes, sir. May it please the court, my name is Bill McCabe. I represent the claimant in this case, who's Debbie Shalaew, and she's the wife of the deceased employee, Paul Shalaew. I'll reserve 2 minutes for rebuttal. In this case, the judge of compensation claims denied the claimant's request for payment of permanent impairment benefits based on a 75% permanent impairment rating for hepatitis C based on an August 14, 2003 date of accident. Now, the judge denied the request for 2 reasons, both of which we contend were erroneous. The first reason the judge denied the benefits is because the judge found the claimant never reached maximum medical improvement from the August 4, 2003 accident. Now, there's no competent substantial evidence to support this finding.
Why? I mean, it seems to be a lot dependent upon the liver transplant. Liver transplant. Why couldn't the JCC here rule that there was still a reasonable possibility of improvement based upon a reasonable probability of improvement based on the potential liver transplant?
Well, there's a couple of reasons. First of all, both doctors who opined on when claimant reached maximum medical improvement, or the employee, both said December 15, 2005. Well, one of them said December 15, 2005. The other said between September and December 05. But secondly, the liver transplant situation, the chance that the claimant might have undergone that shouldn't delay the MMI reading based on those cases that hold that the possibility of having surgery in the future does not necessarily forestall an MMI date at the present time.
Well, he was still being treated with interferon past the December 15th date with the possibility or the probability or hoping to get the liver transplant.
Well, actually, he never really qualified for the liver transplant either. I mean, the doctor that was treating him at the time, she states that he was evaluated, page 784 of the record, he was evaluated and failed to be a candidate for the transplant. And then what was the reason he was not a candidate? She says, well, he was a candidate. I suggest that you can put people on the list, but they may not have a high enough score to get the transplant. You keep monitoring them and hoping that maybe they'll get to that point. But the interferon treatment also, she said the purpose of that was to try to clear up the virus so that if he did have a liver transplant, it increased the odds of it being successful.
And the virus was being cleared up. I mean, he was getting better.
The virus was being cleared up, and she said on page 782 of the record that that's a response to therapy, not improvement in his condition. She stated his condition, she said he never got better, and it just kept getting worse and worse.
Well, it seemed to me, reading the JCC's order, that he interpreted her testimony, looking back, well, his maximum date of improvement had to be December 15th, because looking back, I think that was the day he was the best. He got worse after that. Why couldn't the JCC have rejected that testimony for MMI, basically saying the wrong test was being utilized here? Not whether, looking back, and whether he got better or not, but whether there was a question of reasonable probability of getting better on December 15th.
Well, I think the correct test was being used when the doctor was asked what her opinion was on MMI. I mean, she was actually given the definition of MMI. I recognize that there are a couple of cases out there where a doctor says the person reached MMI on a date, but the medical records refute that. But in this particular situation, I would submit that the medical records don't refute that, because the doctor said he just kept getting worse. He clearly decompensated, especially after December 15th. That was about the last time that he was able to, I know going to work and MMI are not synonymous, but that was the last time that he was able to work full-time, started missing work after that. The January '06 report of the doctor shows that he could only work 1 or 2 days a week. So she treated him for, what, almost 2 years, and that was her conclusion after being told the definition of MMI. It corresponds with the same definition. Dr. Giron, who did an IME, did a medical records review, he came up with the same date after reviewing all of the records. So we don't feel that there's any, not a single doctor testified otherwise. There was a third doctor, Dr. Halal, who had no opinion at all as to when the claimant reached MMI. So here the judge is rejecting the unrefuted testimony of 2 physicians with no other physician testifying otherwise.
But even if we accept that characterization, the JCC does have the authority to reject unrefuted testimony, correct?
Yes. Yes.
So I mean, so the JCC still could say, I'm not persuaded that he had reached MMI yet.
Well, but I don't believe there's competent evidence in this record to support that finding. I mean,
Is that the test? I mean, I know we talk about competent substantial evidence, but when a JCC, somebody has a burden of proof, can't the JCC reject what's being proffered just because of lack of evidence? You understand my question? I mean, we keep on talking about competent substantial evidence to reject an opinion, but can a JCC reject an opinion based on lack of evidence?
well, Judge,
You haven't made your burden.
well, there are cases the judge can reject unrefuted medical testimony. I acknowledge that, but they've got to have a valid reason if they're going to reject unrefuted medical testimony. And I submit.
Well, here, you know, I kind of hinted at it before. Here you're saying they made their estimation of MMI 2 years later. That I kind of feel, and this, I'm reading into this, but it seemed to be in there, that he was saying that their opinion to me was based on that he never got any better after that date.
Right.
I mean, isn't that how you read his order, or read the JCC's order here?
Yeah. I mean,
And why couldn't he do that?
Well, because the best the person ever got, according to the doctor that was treating him, Dr. Soldavila Pico, I believe is her name. Actually, she said the best he ever got was before treatment began, or now when she was referring to the September 12, 2005 date. And then he completely went downhill after that, and treatment rendered after that date wasn't really being rendered with a reasonable expectation of improvement. The liver transplant was something they might have hoped for off in the future. And I cited 3 cases in my brief that does not forestall an MMI date now. The possibility of having a surgical procedure somewhere down the line, that's the Holder Kitchen Cabinets case, it's the Emanuel case, doesn't forestall MMI at the present time.
So on your theory then every single case there would be an MMI date. I mean, even if we have to retroactively determine it, we just look through the medical records, find when the individual was the best, and that would be MMI. Instead of, you know, I thought the definition was more, okay, we're going to treat, we're going to do the best we can, and when we've done the best we can, then we're going to say the person's an MMI and we're going to evaluate. But on this theory, it seems like we're just looking at an individual case and saying, okay, that's the best he was, so that's when MMI was.
Well, I mean, no, MMI is, as long as treatment is continued with a reasonable expectation that there's going to be improvement, then MMI hasn't been reached, even if it turns out that there is no improvement at the end of the line. But in this particular case, it appears from the doctor's testimony that there was no reasonable expectation of improvement after December 15, 2005. Yes, he continued on the interferon treatment, but there was really no reasonable expectation of improvement at that point. And that's what both doctors, that's the sum and substance of their opinions.
Okay, can you just turn to point 2 for a second? Because I found this kind of, you know, I found the whole case interesting, but I found this kind of interesting. I recognize that we have found that for the same disease, you can have 2 deaths of accident.
Yes.
And if you're getting around statute of limitations and some other reasons for doing it. Is there any case where we have said the same disease or same causation factor would allow somebody to collect impairment benefits and indemnity benefits to cover the same period?
No, there's not a case. This is a case of first impression as far as that goes.
Okay, so since this is a case of first impression, because I think that's where we are, doesn't it make sense to limit those cases talking about 2 dates of accident to circumstances where it would be unjust not to allow the claimant to have 2 dates of accident? You understand my question?
I understand your question, but I would disagree. I mean, it's clear from the Jones case and the Michaels case that you can't have 2 dates of accident for an occupational disease. This case, the parties agreed there are 2 dates of accident. There was the August 14th, 2003 date of accident, which is the one we're proceeding on here. And then there was a June 1st, 2006 date of accident. They're 2 separate accidents. What the judge did in this case is he said that if the claimant did reach maximum medical improvement, the carrier could get a set-off for temporary benefits that they paid to the claimant after December 15, 2005.
To cover the same period. I mean, that was his.
But the problem with that is that from June 1st, 2006, the date the claimant had the second accident, that's the temporary benefits were paid under that second date of accident. And our position is you cannot have a set-off of benefits paid on a second day of accident against benefits owed under the first date of accident. And I think the Almond case, which I cited in my brief, supports that. The carrier did pretty much the same thing. There were 3 dates of accident in that case, but 2 of which resulted in a disability. And the carrier basically tried to claim, well, we paid TTD under 1 date of accident.
But there were 2 separate causation factors there.
There were 2 separate causation factors in that case, but the principle should be the same. If there's 2 dates of accident, then you're entitled to whatever benefits you're entitled to for each date of accident. And in this particular case, if the claimants did reach MMI on December 15th, 2005, he's entitled, the very next day is when the impairment benefits are supposed to start, according to the statute. He's entitled to impairment benefits until November 14th, 2006, when he died. Now, they are entitled to a set-off of the temporary benefits they paid up to June 1st, 2006, because it's under the same date of accident, but that was only $792. They're not entitled to a set-off of temporary benefits paid under a second day of accident. There's not a single statute.
What was the purpose of the second date of accident here? Wasn't it in order to increase the death benefits to this person?
Well, that was the net result of it, yes. But
anywhere in the record is there a record as to why they stipulated to a second day of accident?
I don't know if it says why they stipulated to a second day of accident, but the record shows that they did stipulate to a second day of accident. And then they reassigned the temporary disability benefits they paid after December 15, 2005 to the second date of accident for all of them that were paid after June 1st, 2006. There's not a case or a statute that supports what the judge did as far as setting off the temporary benefits paid under the second date of accident against impairment benefits that would be owed under the first date of accident.
Were they obligated to stipulate to a second date of accident?
No, they weren't obligated to. I mean, I don't know what happened.
So once they do, then they have to buy everything that a second accident would have.
I would say yes. I mean, it's agreed there's 2 days of accident, so then we proceed accordingly. I'll save the rest of my time for rebuttal.
Thank you.
Good morning, Your Honors. May it please this honorable court. My name is Lamar Oxford. I'm here on behalf of Orange County.
Mr. Oxford, let me hit you up right away.
Yes, sir.
I want to get the point that we're just going over with Mr. McCabe. You stipulated, I don't know if you were the trial attorney, I don't believe you were, but there was a stipulation as to a second date of accident. Why shouldn't you be bound to that stipulation where you did not put any limitations in there?
We agreed to it and didn't contest it because another panel of this court had issued its Jones opinion in the wake of the Michaels opinion, in which they said in hepatitis C conditions, if you go back to work and then you go back into treatment and you start missing work again, we're going to give you the benefit of having gone back to work. We're going to give you a new date of accident. And specifically on the facts of Jones and Michaels, that had to do with average weekly wage.
That's equitable. I mean, that so these persons can get new benefits, they're going out of work again.
Look, we couldn't have won that argument, Your Honor.
I understand, but when you stipulate, if you want limitations on that stipulation, saying this is a second date of accident, but only for these purposes, shouldn't we make it your burden to put that kind of limitation in your stipulation?
Well, it's not so much a stipulation as an agreement to a claim that was filed 2 years after the death. It's not like we can put conditions on, under the self-executing nature of workers' comp. Once somebody makes a claim, we analyze the facts, and we analyze the new law that has now been issued on this very type of case. We have to comply.
In either Michaels or Jones, were new impairment benefits paid, or all we were doing is adjusting the average weekly wage?
Exactly. And I don't mean to speak too loosely, but for those of us who represent employers who have employees who from time to time will get an occupational disease like hepatitis, we are still digesting the impact of Jones and Michaels, and in this case, the claimants bar are trying to take the ramifications of Jones and Michaels far beyond what we believe this court intended, and way far beyond what the legislature could have ever intended. Because the logical extension of this argument is that if you have a hepatitis C case, and you have a person who lives for years undergoing treatment off and on, you could have 10 dates of accidents. You could have 10 separate impairment ratings, and under this logic, you'd have 10 bonanzas. It can't be intended in a situation where you have one condition, one employer, one payment of benefits. In this situation, let me summarize real briefly what happened in this case. Bill knows it. We accepted the 03 diagnosis of hepatitis C, kept him at work, kept him on full salary, paid him full salary when he went for treatment, or TTD, one or the other, for the rest of his life. We provided full hepatitis C treatment. Not an issue here. Very expensive. We paid full death benefits after he died in November 2006. No claim for a second injury by that point in time. Did everything we were supposed to do. 2 years later, they file a claim and they say, well, 5 months before he died, he had a separate period of interferon treatments where he was out of work. And now that the first DCA has issued the Jones and Michaels decisions, we're making a claim saying, you need to give us a second date of accident, because that will increase the widow's death benefits by 50%, and it'll increase the funeral benefit by 50%. In the context of Jones and Michaels, we agreed. We had fought Jones, that's Orange County, and lost. We came back, we agreed. 2 years after the death, we go back and, in lump sum, pay the widow a substantially more amount of benefits for an 06 date of accident. And then, after we do that, after the claimant's attorney has got his client essentially a bonanza that wasn't expected by the time her husband died, then they come back and say, okay, well, now that you've done all that, we're going to go back and say that he had a 75% permanent impairment rating from the original accident. And even though you've increased so much more of the benefits that you never stopped paying the whole time, and 2 years after the death, you've paid so much more because of a change in the law, we're now saying that on top of everything else, while he was alive, despite the fact you paid him 100% of what he was due, now you owe him a 75% impairment benefit.
Does Chapter 440 anywhere make reference to a second date of accident?
No. No. The case they rely on different parts of the body, different causations, not relevant to when you have one disease. No evidence that this gentleman ever got pricked again or ever was contracted hepatitis C. One time.
Is there an equitable provision in Chapter 440, something that says, for the courts to do equity?
I think judges just do that as a matter of fact. I mean, if ever a case cried out for the application of common sense and logic, and Judge Condrey used the words logic and consistency, it's this one. This employer did everything it was supposed to do.
So the implication of that is we were wrong in Jones.
In a perfect world, Your Honor, in a perfect world. Now, on the MMI issue alone, this court can affirm, limited to this facts alone. In a perfect world, this panel could revisit Jones and Michaels and make it real clear to everybody in the state that they should be limited to their facts. And they should not be allowed to apply to a situation where you can have an infinite number of accidents, depending on how long the patient lives under treatment, going back and forth to work, and an infinite number of MMI days, and literally an infinite number of permanent
Well, applying
impairment
that
days.
logic in Michael's, didn't Michael's went in and out of treatment several times, correct?
Yes, sir.
So Michael would have probably had maybe 4 or 5 dates of accident. And he could have started over his impairment benefits clock each time. He could have started his 104 weeks of TTD each time. Would that also be?
But not at the same time, which is what they're trying to do here. TTD and those type of benefits are paid for periods of time. Permanent impairment benefits are paid for periods of time. They can't be paid after death. They're not paid in lump sum, and usually they're paid every 2 weeks. But it's during a period of time when you're permanently impaired. Well, now when they're claiming this gentleman was permanently impaired, they're also saying, same lawyers, same person, same condition, that he was temporarily totally disabled, and we paid those. That's why Judge Condry saw the blatant unfairness of what the claim ultimately is here, and noted that for that time period at issue, we had paid over $15,000 in benefits, and even if he was entitled to permanent impairment benefits, that would be $14,000. The judge actually found we overpaid. That Orange County did, and the employers are doing everything they can to deal with these difficult situations in hepatitis C occupational disease cases as a result of the rulings in Jones and Michaels. We accept that that's the law currently. In a perfect world, this court would write an opinion, affirm Judge Condry's reasoned opinion on these facts, but also limit Jones and Michaels to their facts, because it's almost absurd to think that you could have 15 dates of accident, 15 dates of MMI, and 15 permanent impairment ratings, all separate for the exact same condition, for the exact same employer. And that is exactly the argument here, no matter how well the smoke screen is put up. Going back to MMI, doctors choose their words carefully, but not as carefully as legislators, judges, and lawyers. This doctor admitted, and keep in mind, all of this is 2 years after the fact, 2 years after the gentleman died. We had written her a letter. Did he reach MMI while he was under your care? She never even responded. Then 2 years later, after the claim is filed, after the attorneys get involved, she's asked these questions.
We have doctors all the time, though, to look back and come up with MMI dates. I mean, that's not unusual.
It's not. It's questionable, but it's not unusual. It's especially questionable with regard to
Well,
the other doctors.
I'm not sure how questionable it is when somebody's treating somebody. They're not thinking necessarily about what I'm going to testify to down the road.
No, she was asked while he was treating, and never responded. But it's more questionable with regard to a hired gun like Dr. Huron, who never saw this gentleman ever, and just looks at records 2 to 3 years after the fact and draws.
I like the characterization.
Well, I don't mean to. I apologize if I'm speaking too loosely, but you can imagine all the employers' reactions to these sorts of things. A doctor who never saw the patient 2 years after the
No
patient
hired
dies.
guns on the other side of this, Ralph?
I mean, he decides not only that the MMI date was some date he picks out of the air, but he gives him a 75% permanent impairment rate. But Dr. Pico, the one who did treat, was asked, was your treatment designed to bring improvement to his condition? Yes, we were trying to get rid of the virus before he got the transplant. Did you expect improvement over
At the
this?
same time they were saying they were getting rid of the virus, they were saying he was decompensating. How do those two things work together? That getting rid of the virus is not necessarily going to, help with.
She testified that this gentleman ultimately died of a complex set of factors, including cirrhosis of the liver, a different condition, a hematoma that led to a brain lesion, on top of the hepatitis C that he was battling. But her treatment was designed to lower his virus count so he could become a better candidate for a liver transplant, and she testified that it was working, that his viral count went down to almost nothing. But they couldn't continue to pursue the transplant.
So it wasn't just palliative treatment. This was treatment designed to make him better.
Exactly.
And
No
it was
wonder.
within a reasonable degree of medical practice, scope of practice, that you would do these kinds of treatments in order to have the patient improve.
Exactly.
So whether or not he improves isn't the test, it's what he's being treated for.
His viral count became better and it was non-detectable at some point. Yes. is that improvement in his condition, that is response to therapy. That is semantics that Judge Condrey saw right through, in our opinion. An interferon treatment is intended to improve a person to the point that they can get a liver transplant. And that's exactly, this gentleman was undergoing it until a complex series of factors finally, unfortunately, brought us death. You could affirm on the MMI alone easily by agreeing with Judge Condrey on the admissions of the treating physician and easily rejecting the other MMI opinion from the doctor who never even saw him. But this case has, if you go beyond that, and I'm not recommending you do, but if you do, it has ramifications. These occupational diseases cases, and hepatitis in particular, based on Jones and Michaels, can become absurd, in our opinion. And double recoveries, bonanzas, things that the legislature could not possibly have intended, are the very result if you accept the claimant's argument in this case. So we respectfully submit that Judge Condrey realized the significance of this case, realized that elements of it are of first impression, analyzed these facts in the context of the law, and made a very reasonable decision. We would respectfully request affirmance. Thank you.
Thank you.
The thing about two accidents, what if the man had two accidents who's low back? He's entitled to benefits for each date of accident for low back injuries.
We have two separate causations there, though.
Well, maybe the same employer might have gotten it the same way, lifting a heavy tire or something like that. And there's no bonanza or repeating of benefits. If the man got a 75% permanent impairment based on his hepatitis C for the August 14, 2003, then clearly if he hadn't died and he had a second impairment rating after the second one, he wouldn't get, he's already been paid 75%, he wouldn't get any more. As far as the equities of a judge of compensation claims, I mean, I'm sure there's many, many cases where equity would prevail on the side of a claimant. Now, as far as the MMI is concerned, this court, it's said in a number of opinions, I'm quoting from Lemmer here, but it says, because the question of whether a claimant has reached MMI is essentially a medical question, it should be answered by medical experts. Here we have two medical experts, both of whom said it was December 15th, 2005, and both did it independently of each other. Dr. Giron, the IME, first rendered that opinion in September of 2008, which was before Dr. Pico's deposition was ever even taken. And when her deposition was taken, there's no indication she had any idea what Dr. Giron said. So two different doctors, independent of each other, December 15th, 2005, and on page 789 of the record is where Dr. Saldavita Pico was read the definition of MMI. There's no expert testimony to the contrary. I don't know why they didn't. I don't know why the employer carrier didn't get an IME, perhaps to render a different opinion. But to affirm the judge in this case is to affirm a ruling when all of the medical testimony is contrary to it.
What about the portion of the transcript that Mr. Officer just read?
Well,
concerning the reasonable probability that this treatment was being given with the reasonable probability that this person would improve.
Well, on the quote that he said, this is a response to therapy, the next sentence of that is not improvement in his condition. And after giving the definition of MMI, she goes on page 796, she says, that's probably the most, she thought initially September, she said that is probably the most likely time that, based on your definition, when he reached that maximum medical improvement before he decompensated. And then, can you give me the date, doctor? I mean, sometime in the fall of 2005, between September and December. It's page 796 of the record. Thank you.
Thank you.